Well, I think Emily wrote a fantastic chapter on examinations for discovery and preparedness. It really is a toolkit for any lawyer who's taking in an intake or preparing for discovery, obtaining documents, getting the records together to make sure they're complete, and then creating a roadmap to go through the discovery process, the post-discovery process, effective preparation for mediation and trial. It really is an excellent toolbox she's prepared there.
I would say the same. That discovery chapter was a chapter that I wish that I'd had access to as a junior lawyer running one of these occupiers liability claims for the first 5 times, first dozen times. It would have been really helpful, I think, to have somebody set out a chapter giving me a roadmap of, okay, what do I do next? I've got this, from the inception of the claim all the way through discoveries and then potentially mediation and resolution. So that was really forefront in my mind writing that chapter, is how can I make this the most helpful possible to a junior lawyer?
Yeah, I think it's just a matter of, from the plaintiff's perspective, you want to maximize recovery. From the defense perspective, you want to minimize exposure. And so between that pendulum, there's a lot of good information that will help you do that. Prepare your case, anticipate your opponent's case, and likewise, because so many matters settle before trial, and in fact, systems are geared to achieve numerous opportunities for discussion, negotiation, and settlement. It's important for lawyers to have a resource like this so they can do that. Maximize recovery or minimize exposure.
I was preparing for a mediation a couple of weeks ago and drafting my mediation brief, and one of the issues was sporting liability in the occupiers liability context. And I thought to myself, oh, what did I say in that chapter? I know we discussed this, and I know we had some principles. So I actually did pull up the draft and go back and look at what I'd written, and actually ended up taking some of that and including it in my mediation brief. So I think for more senior practitioners, it's going to be the type of thing where, oh, I'm dealing with a really kind of interesting issue on foreseeability. Let me flip through the book and see what they've said, review kind of their analysis. Are there any cases that are similar enough that I should be pulling those and taking a closer look at them? So that's how I've used this book in my practice and how I envision more senior counsel using the book as well.
Yeah, and I think particularly in these days, the law is evolving so rapidly. There's so many different types of premises and different uses to which they're being put, the types of uses, the types of premises, what's reasonably foreseeable, what's known, what proactive steps an occupier can take. This is stuff that might not have been available 20 years ago, right? And because of that, because of the changing use to which premises are put, sometimes senior practitioners don't understand availability. Weather records are a good example of something that might not have been available on public record even 15, 20 years ago, which now go to the heart of foreseeability and the proactive steps required to ensure that premises are reasonably safe. We've gone a long way from looking out the window to see if it's going to snow to have 14-day forecasting so you can plan appropriately, and that falls under the rubric of what have been reasonably expected from a commercial occupier, and then a discussion about, well, what's reasonable from a residential occupier, and where's the difference and where's the balance. And I think this book does a good job for senior practitioners, particularly to understand some of the evolution in the law that requires maybe a different perspective or a more holistic perspective.